Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. And I just have to tell you, I have the smartest audience in all of YouTube land. I receive things from listeners quite frequently, and I received one today that I felt like I needed to make into a video. So thanks to Ken for this. This is a case of a pretty bad lawyer. Let's go down to the beach and talk about that. Okay, you're going to realize that was a pretty bad pun here in just a moment, but there was a lawyer by the name of Dan Purdy, who is an 86-year-old lawyer in Kansas City, who, for whatever reason, decided that apparently that it was appropriate to touch them in ways that he should not have touched them in. It really boils down to what I believe was probably an assault. The jailers in that particular jail made a report, and they contacted the Office of Chief Disciplinary Counsel. The Office of Chief Disciplinary Counsel did an investigation, and what they found led them to a disciplinary hearing panel, and the disciplinary hearing panel decided that this particular lawyer should be disbarred. He wasn't disbarred. He contested that and took it to the Missouri Supreme Court. By a 4-3 vote, he was suspended indefinitely and cannot apply for reinstatement for at least 1 year. He has been suspended on the basis of potential harm to others since 2021. But now he is indefinitely suspended and can't apply for reinstatement for at least another 12 months. Let's go through the opinion, and I'll tell you a few things, and we can talk about this more here in just a moment. If you hang on till the end of this opinion, I'm going to have a question for you that I'm going to ask you to leave some comments for an answer. The opinion that was released by the Supreme Court on Tuesday, and it says that this particular lawyer committed multiple violations of the rules of professional conduct. And then the disciplinary hearing panel recommended that he be disbarred. And he rejected that recommendation, and that means that the court has to impose discipline. So what he says is, look, considering the amount of time I've been suspended, you should just immediately reinstate me. That was going to be a non-starter from the beginning. Following a de novo review of the record, and what that means is they look at everything as if they were determining this for the first, as if the case was being tried to them. After consideration of mitigating and aggravating factors, this court orders Purdy indefinitely suspended with no leave to apply for reinstatement for 12 months. That is an exceptionally gracious dispensation here. So let's look at the facts and procedural history. Purdy is an 86-year-old attorney. He's been admitted to the bar for 55 years. His license has been suspended since December of 2021. In September of 2020, the Vernon County Sheriff contacted the Office of Chief Disciplinary Counsel and said that 4 female clients in the jail interview room had been essentially assaulted. The video footage depicted Purdy doing things that can't be discussed on YouTube. But the long and short of it is that he knew what he was doing was unwelcome, and the ladies that were interviewed each confirmed that those measures were unwelcome. And then one of them described him in a rather colorful way, as you can see. And the officers confirmed that Purdy never told his clients that the conduct was in exchange for payment or reduced legal fees. So in addition to that incident, in March of 2021, an assistant prosecuting attorney for St. Clair County contacted the Office for Chief Disciplinary Counsel and said in open court, the courtroom's video footage showed Purdy touching his client inappropriately. The client at issue, however, submitted an affidavit stating she did not believe that he touched her inappropriately. And then there was an incident in Purdy's vehicle in September of 2021. He was transporting a client and he reached across the seat and did things that he clearly should not have done. The client later stated that that was unwanted. And then when he went before the disciplinary hearing panel, the Office of Chief Disciplinary Counsel and Mr. Purdy submitted a joint stipulation of facts, joint conclusions of law, and joint recommended discipline. What that means is they both agreed to what the facts were, they both agreed to what the conclusions of law were, and they both recommended a level of discipline to the hearing panel. In the joint stipulation, they stated that he should be suspended indefinitely with no leave to apply for 12 months. Then the DHP conducted an evidentiary hearing. Following its hearing, the DHP found Purdy's conduct constituted multiple violations of Rule 4.1.7, 4-8.4, D, and G. The panel believed that he exhibited a continuing pattern or practice of improper and disturbing conduct which continued even after the present case was filed against him. They recognized that he was given access to these vulnerable clients due to his role of attorney, and he could not be trusted not to repeat his prior actions. They recommended that he be disbarred. Well, Mr. Purdy didn't like hearing that, so he took it to the Supreme Court. He had been suspended since December of 2021, and so the court, in looking at their prior precedent, said, we've got the authority to regulate the practice of law and administer discipline. We review the evidence de novo, and we independently determine all issues pertaining to credibility of witness and the weight of the evidence, and we draw our own conclusions. And the court found the DHP's findings and conclusions as advisory, meaning that it can accept or reject any of their recommendations. And basically what happened here, I'll just cut to the chase, is that they accepted the facts, but they rejected the recommendation to disbar. So based on the record before the court finds Purdy committed multiple violations of the rules as shown below. Well, 4-1.7 is a concurrent conflict of interest rule, and it says that when he put his own interests ahead of his client's legal needs, he was in violation of that rule, and he had a concurrent conflict of interest. He should have withdrawn. Rule 8.4D provides that you commit a professional misconduct by engaging in conduct that is prejudicial to the administration of justice. And indeed, they found that he had done that. He had committed acts that were prejudicial to the administration of justice. And they also found that in engaging in harassment, including but not limited to bias, prejudice, or harassment based on sex, the court found that he had committed professional misconduct with respect to Rule 8.4G. This court finds by a preponderance of the evidence that Purdy committed those acts, and they amounted to 18 acts of professional misconduct. So, given the inherent authority to regulate the practice of law, they say the purpose of discipline is not to punish the attorney, but to protect the public and maintain the integrity of the legal profession. Indeed, if you want punishment, you have to go to the criminal law. And I am frankly amazed that the criminal law did not come into this case. Those twin purposes may both be achieved by removing a person from the practice of law and indirectly by imposing a sanction which serves to deter other members of the bar from engaging in similar conduct. Well, this sanction does not do that, as the dissent points out. So they look at the duty violated, the mental state, the potential for actual injury, and the existence of aggravating and mitigating factors. So, in this case, his most egregious act of misconduct was his failure to avoid conflicts of interest by allowing his personal interests to interfere with his client's legal needs. Once misconduct is established, this court may consider aggravating and mitigating factors. Purdy's conduct affected some of the legal system's most vulnerable persons, women facing criminal charges. 4 of the women were incarcerated and unable to flee. Additionally, he'd been practicing law for more than 55 years and should know that his misconduct was inappropriate. So in mitigation, the only thing they can say in mitigation is, well, he admitted it. Well, of course he admitted it. It was on video. What's he going to do? Say the video had been doctored? Of course not. And it was on video multiple times. There were 3 pieces of video that showed this misconduct. The hearing panel found that his testimony that he would not allow similar acts to occur in the future to be both disingenuous as well as probably false, because he continued his pattern of conduct even after the case was filed against him. So the court then looks at 2 similar cases, one from 1995 and one from 1986, where the discipline was basically suspension with reinstatement after 6 months. And Mr. Purdy says, hey, my case is just like these. And in fact, he says it's less egregious than the attorneys in Littleton and Howard. And the court disagreed, and it says, no, it's not less egregious, it's more egregious. And so we believe that the proper punishment here is suspension with reinstatement after 12 months. If he can establish at that time that that he has the moral fitness to be a lawyer. And that will be determined on evidence to be submitted at least a year in the future. The privilege to practice law is supposed to only be accorded to those who demonstrate the requisite mental attainment and moral character, which leaves you to wonder how he could be considered to be fit to maintain the privilege of law ever again in the future, given what he did. But we'll leave that for another day, or actually we'll leave it for the dissent. So they say we suspend you indefinitely, leave to reapply within 12 months. Here is what the dissent says. He didn't bury the lead. This is Judge Fisher. I must dissent. I, like the disciplinary hearing panel that heard the evidence in this case, am of the opinion that Mr. Purdy should be disbarred in light of the egregious and outrageous conduct perpetrated. I am deeply distressed that this court merely indefinitely suspends Mr. Purdy with no leave to apply for reinstatement for 1 year. Implicit in the principal opinions analysis is that Mr. Purdy only needs to be indefinitely suspended. In my view, neither the race, gender, ethnicity, or age of an attorney should be taken into consideration to determine appropriate discipline. In my view, Mr. Purdy's conduct, which was clearly and explicitly depicted in the video evidence, warrants disbarment. He goes down to say that the conduct is unbecoming of a lawyer in the legal profession, something with which I would agree, and that it's made even worse because it continued even after the present case was filed against him. He then says, look, the Missouri bar had 17,000 lawyers when I took the oath of admission in 1988. As of 2023, the Missouri bar has at least 30,700 licensed lawyers, or approximately 1 lawyer for every 200 people in the state. It is inconceivable that we will deprive the public of adequate legal representation by disbarring a few of those who prove themselves unqualified to represent the public because they attempt to seek things from their clients that they should not seek. And he says this court should disbar Mr. Purdy. And I would agree completely with Judge Fisher in that regard. So let me ask you, do you think this is the first time, or you think these are the only clients that Mr. Purdy ever did this to? Or do you think these are just the clients that caused him to get caught? Let me know in the comments. As I've looked at this case, I have wondered why, having been observed directly and recorded on video doing things that no lawyer should ever do, why this gentleman was not charged criminally. Apparently there was some reason not to do that, but if I had been the prosecutor in that county, I would have tried to make an example out of him. I realize he's 86 years old and he's probably not got a lot of time left to practice law. And I also realize that he's done a lot of work for indigents, and that's, a laudable thing. But here's what I have found in a lot of these cases. Whether you're talking about school teachers who fool around with their students or lawyers who fool around with their clients, the bottom line is that the person in authority, either the teacher or the lawyer, is exploiting the person who is not in authority, the student or the client. In the case of the lawyer, it's particularly egregious because you have someone who is sitting in jail. They have a criminal charge. They are looking at either spending additional time in the county jail or potentially having to go to the Department of Corrections. Either way, they do not have a bright future. And you have somebody coming in to saying, hey, look, I'll represent you. I'll do what needs to be done, possibly even keep you out of jail. But there's a catch. And even though in this case there is no evidence that he demanded that these people do things for him as return for him providing legal services, the bottom line is that it is just an icky situation. You can't take advantage of clients. You have an obligation as the lawyer to put the client's interests first. And what this gentleman did is put his own deviant interests first, and that should never be the case. I am certain that there are a lot of people out there who, at some point in their life, have had a situation where someone has tried to exploit them. It's not your fault. It is the person who is trying to exploit you. That person is at fault and not you. And so you should have absolutely no shame about going to the prosecutor or the sheriff or the state police, whoever you have to go to, and report that misconduct and do what needs to be done to make sure, not so much to vindicate your rights, but to keep the other people from having the same problem. In this case, there were multiple people who were taken advantage of. And if the first person had pushed back loudly and competently, then there wouldn't have been additional victims. But of course, when someone is a predator, they prey on people who are at their weakest. And when you're in jail, the last thing you want to do is cause more of a stir, or perhaps cause the one person who is trying to help you to run afoul of the law yourself. But when that happens, you should absolutely take action, because if you don't, other people are going to fall victim, as was the case here. The suspension for 1 year, I think, is overly generous. Had I been one of the sitting judges on that Supreme Court, I would have disbarred him. Now, interestingly enough, you would think that with 3 women and 4 men, that maybe the breakdown of the judges was the people who were in favor of just doing a 1-year suspension would be the men, and the women would be the ones advocating to have this individual disbarred. But that isn't the way it went. Judge Fisher wrote a very strident dissent, as we talked about in there. And I think that he should be lauded for that, because it was a very good opinion. When you have one lawyer for every 200 residents of the state of Missouri, you are not going to significantly reduce the pool of available attorneys by getting rid of one 86-year-old lawyer who shouldn't be doing what he is doing. I hope you will forgive me for not using direct language here, but YouTube doesn't like it when we do that. And it is more important for me to talk about the more important things, the conflict of interest, the abuse and exploitation, than it is to talk about things that have a more prurient view. If you have any questions, please feel free to leave them in the comments down below. My thanks to Ken for alerting me to this particular case. And again, if you have an opportunity today to do something nice for somebody, do that for me if you would. Have a great day, and I'll catch you down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.